Hello everyone, welcome to the latest IBA webinar, which is entitled IBA's Masterclass, Managing and Preparing for Defaults and Repossessions. My name is Phil Seymour, Company President at IBA, and thank you for joining us today. We strive to maximise opportunities and minimise risk across aviation assets, and we do this through our advisory services, aircraft and engine valuations, practical asset management and technical services, as well as providing data intelligence through the platform IBA IQ. As you can see from this slide, we've got a lot of experienced folk who manage aircraft. We've been managing aircraft for several funds and leasing companies and banks around the world. And obviously, in the current situation, there's plenty to be managing. Looking at the numbers, we're close to 1,000 people who registered, so we do expect about 500 people to tune in live. Some brief introductions. I'm pleased to welcome our very experienced panel. We're joined today by Oliver Hipperson from Clifford Chance. Oliver is a partner who's advised and is advising banks and lessors on a wide variety of airline failures and restructurings, and has coordinated repossession activity in many countries. And we worked alongside Oliver and Clifford Chance in the past. Peter Walter, IBA's Head of Asset Management and Technical Management Services Division, who is especially well placed to join us as he has a finance and banking background. Also, Ross Armour, one of the most experienced IBA technical managers in the field, who's been project manager on the ground in these repossession situations. Now, I do want to stress that neither IBA nor Clifford Chance advocates repossession as the first option. It's always the last resort. And as you'll see today, it's complex, expensive, and taking on the responsibilities of real ownership of the asset with ongoing management, insurance and storage costs add to those complexities. So as a reminder, we designed these sessions to be around 40 to 45 minutes of opinion and analysis, the remainder of the time to address your questions. Thanks to those of you who have submitted questions already. We'll be taking more questions during the webinar, so please do ping them over via the questions link on your control panel, and we'll look to address them where we can. So whilst we've handled many of these webinars remotely, please bear with us during the slide transitions. It may take a few seconds. So on to the first slide, please, Lucy, as we just setting the scene. Those of you who've joined us in the past will have seen this graphic. I was going to say we update it weekly, but those of you who get the news feed will probably see that overnight LATAM, Argentina, ceased operations, so I think we need to be doing this on a daily basis. This really just sets the scene. I won't go into the details here. I think we went through a period of 4 years between 2014 and 2018 where the industry was doing reasonably well. But I think as the next slide shows, really this is some IATA data, which is really just points the finger at the almost hand-to-mouth existence that many airlines were participating in, and we've really got even the median of those shows that most airlines only had a couple of months of cash at the start of this outbreak. So I think we do want to kick off with the first polling question, just to get a feel of the confidence that's out there at the moment. So with this question, in your opinion, in the next 12 months, will we most likely see more airlines fail outright, more airline requests for government support, or are you in the optimistic camp of airlines getting back to normal? You've got 10 seconds to decide which one you think might be more appropriate. Let's have a look at the responses. Okay, well, there's a very optimistic 6% of you, and hopefully that will be the case. Obviously, some huge expectation in terms of whether airlines will fail outright or more requests for government support. I think this transition going from grounding of aircraft into mobilisation again is going to be a critical period in terms of cash. So just one more slide from me, and then I'll hand over to Oliver. But really just looking at, a lot of questions we have is, is this really about repossession or is it early surrender? And clearly, following the top line here, an early surrender is clearly a much better way to go. It usually means that the airline is still in operation and can support the return of the asset. A repossession tends to lead to airline employees being moved on by the administrator, a real minimum amount of staff available to work with, and obviously a much more difficult process. And here, there's obviously a difference between lessors who are really quite proactive and banks who may be a little slower getting into action. So that's just setting the scene. I'm now going to hand over to Oliver to start the Clifford Chance presentation. Morning, Oliver.
Morning, Phil. Thanks, everyone, and it's a great pleasure to join the IBA team today for this webinar. I'm very often asked how to plan for an airline bankruptcy or an airline distress scenario. So when I get the phone call, usually very late at night, about an airline in distress, I thought it'd be helpful just to run through a few of the sort of key contingency planning steps. I suppose it's worth mentioning that the primary objective here is to put yourself in the position where you can act decisively and quickly. You do not want to be the last person to get your aircraft out of a bankrupt airline. So establishing the right team is clearly key. And of course, no team is complete if it doesn't include both IBA and Clifford Chance. The choice of local counsel, particularly the airline's home country, is also very important. You must ensure you have good quality, unconflicted, on-the-ground advice. And so once you've established the team, it's a question of deciding how decisions will be made and by whom. Who's going to sign documents? Are there going to be multiple signatories? Who's going to approve payments? It may be that cash needs to go out the door at various points in the process. And remember that some documents may need to be witnessed. So would the signatory's personal situation provide for that in a lockdown? And just so everyone on the call is aware, family members can be witnesses to documents. I often get that question. If necessary, and quite often it will be necessary, give powers of attorney to local counsel and other people in country, and send original documents like deregistration, powers of attorney, and ADIRs there. But then comes the job, which is often more difficult than it seems, of simply locating the loan and the lease documentation. It's not always as easy as it sounds, especially where the lease has been novated multiple times, as is often the case with all the trading. And at the moment, it's quite acute because the current wave of lease and loan deferrals is creating a huge amount of sort of short documents, amendments, agreements, and sort of side letters. Quite difficult to keep track of those. So having sort of internal document storage arrangements is very important. And finally, just on letters of credit, where you do hold LCs, pull the original back from storage if you need to, and keep it safe, because you may need that to make a demand. So then you found the documents, need to work through them and consider what sort of consents and authorizations might be needed. And that will be dependent upon the transaction structure, of course. But one thing I will say here, and I can't stress this enough, is that where there is financing on the transaction, it's critical to engage the lenders early. It's often very difficult for a big institutional lender to take quick decisions. And that's not a criticism, but it's just a reality of the sort of committee approval and decision-making processes in the banks and other similar institutions. One will also need to look at the leasing arrangements and the ownership arrangements. If you have an owner trust, it will be necessary to get a power of attorney from the owner trustee, for example. And finally, on this slide, we need to consider the airline's local insolvency regime. So when you engage local counsel, and when we engage local counsel on behalf of our clients, one of the most important work streams is to understand how the insolvency regime might impact the exercise of rights under the lease or the loan documentation. For example, the local regime may give a liquidator or a bankruptcy trustee or similar official the power to freeze leases, or will allow the airline or even direct the airline to carry on operating the aircraft. A liquidator may be able to claw back payments which have been made prior to solvency, sometimes going back 6 or 12 months even. And that could include rent, maintenance reserves, and even security deposits. The local insolvency regime can even have what we call extraterritorial effect, which would sort of potentially restrict repossession or enforcement of security, not just in the local regime, but elsewhere. And of course, we see that extraterritorial effect most vividly in the US Chapter 11 bankruptcy filings. Avianca and LATAM filed for bankruptcy protection recently in the US. And one of the effects of that is an immediate and worldwide automatic stay of actions against the airline or its property. That would prohibit repossession and even prohibit serving a default notice. And breach of that automatic stay would put you in sort of contempt of the US courts, which is generally not somewhere where you want to be. And quickly, final note on this is just on Cape Town. I get a lot of questions about Cape Town. I'm not going to go into it in a huge amount of detail here unless there are questions coming through the webinar. But we, of course, do need to check if the airline's home country is a Cape Town contracting state. If different, the state of registration is maybe a Cape Town contracting state. But we also need to dig a bit deeper, analyze how the country has ratified Cape Town, because as you know, there are certain optionality within the treaty, and you can, as a country is ratifying, can switch on and switch off certain elements of it. So Phil, I will hand over to you there, I think, to talk about your element in your role in the contingency planning phase.
Yeah, thanks. The next one actually Ross will talk to, but I just want to jump in there and ask Pete. Oliver mentioned there about getting the lenders involved. I mean, I can imagine this can be a real bottleneck, can't it? I mean, have you had experience where with your sort of previous experience where you've got a problem, but perhaps there's a syndication behind it, and really when you want to act in a matter of hours, it can probably take days or weeks, can it?
Yeah, I mean, I think it's a twofold issue here. One is, as a financier, often if you're providing funding of facilities into an operating lease structure, you can see there's a default that's going to be coming. Sometimes we're in an environment where there's been a significant shift in aircraft values, and there might be a non-recourse loan, and you're expecting that final bullet payment to be paid by the aircraft sale proceeds at the end of the lease, but the market value has dropped. There's going to be a default maybe 6, 9, 12 months out, but there's effectively nothing you can do at that stage. So it's important to get your planning processes in place in anticipation of that aircraft coming back and doing everything you can to maximize the value at that stage. Make sure you do have your records, something that is going to impact on the value of the aircraft at a later date, get the repairs properly documented, etc. Moving the other side of it, when you're actually at a default or an impending default, one of the significant issues we see, or I saw as a financier, and also see it as an advisor, is when you have syndicates and the facility agent needs to refer back to all the banks, and some of the documentation will obviously have some commentary on how decisions are made, whether it's majority, but you need to make sure that all of those parties, and Oliver touched on this, that the decision-making process can be difficult and frustrating, and if you're unable to move quickly, you can incur more significant problems as a case of not being able to do that. And we've experienced that recently, whereby a structure didn't actually have an appointed facility agent. It was just each lender came in with their percentage. So we're having to work hard with that syndicate now on how to actually approach that. There's no one single entity that takes control of a transaction when it moves into default. So if you're in such a situation, perhaps start thinking about it now and put some planning or an agreement in place as to how to deal with situations and making those decisions.
Okay, yeah, thanks, Pete. So next slide, Ross, is also entitled Contingency Planning, but it's sort of at the metal end. Can you just run us through some of the key points on this one?
Yeah, sure. Thanks, Phil. Morning, everyone. So as Oliver and the legal side of things are contingency planning, it's obviously imperative we figure out what we're going to do with the airplane, how we're going to get the airplane back. So firstly, are we looking to repossess a serviceable airplane? Where in the world will that repossession take place? If the airplane is in service on a route network and being used daily, we could look at the most opportune time to repossess at the most appropriate place. The close monitoring of a fleet in financial difficulty is paramount, really, so that everyone's fully aware of when and where the aircraft are operating to. Understanding what engines are installed on the airplane, so it might not be the titled engines which belong to that airframe, it may be someone else's. Where are the title engines for that aircraft? As a rule of thumb, any aircraft kind of over the 4 years, 5 years old, we would expect some engine changes to have taken place, and perhaps the titled engine not to be installed due to going to a shop for a repair or for staggering reasons for the airline's utilisation rates. Repossessing the airplane with someone else's engines on it, we would default back to the legal team to give us advice on what we need to do. Recent experience, last 18 months, we have been in that scenario, but we have had open engagement with both the aircraft owner and the engines installed. We've been able to come to some agreements so we can move their aircraft around. So it's worked out well. Repossessing an unserviceable airplane. So historically, when we look at the nature of airline default and failure, it normally has some aircraft that have been grounded for a significant period of time just due to the route network shrinking, and an aircraft on the ground becomes a great source of spares for an airline rather than going to the market to buy rotables and expensive parts that need to be replaced. You have an asset there where you can take the parts, place them on other aircraft, and keep the rest of the fleet serviceable. So we had a 777 last year, based in Asia, been on the ground for a significant period of time. When we got involved in the repossession, we had a robbery list of 200 items on that particular airframe, which totaled just shy of $10 million worth of parts. That didn't include one of the engines, which was in a shop in the UK, and that engine had been through performance restoration. So when we got the legalities out of the way to get rights to the engine and understand what had been carried out, we didn't know whether it was waiting to go into the shop or whether it was coming out. It was coming out, and there was an $18 million invoice associated with that overhaul cost, which obviously the engine overhaul facility wanted to know who was going to pay that before releasing any engine. Aircraft records, where are they stored? We see it with multiple airlines across multiple locations where different types of airplanes are operated out of different bases. The same stands for the records. You may have the Airbus records for a particular airline in one major city, the Boeing records are in another city. We see it with engines as well, so you might have the airframe records in a city. The engine overhaul facility may be somewhere else, several hundred miles away. The records for the engines are stored there. So understanding those complexities prior, or having an understanding of those complexities at all times, really would be a great due diligence process of, if we did end up in a default situation where we have to get these airplanes and these records back, how and when do we do it? Myself and Phil have spoken about it before, where we look at the biggest airlines in the world, where naturally we say, well, they're too big to fail, but if they did, what would we do, and how would we get those airplanes back? And planning for that is just a good insurance policy.
Okay, yeah, I mean, we thought Swissair and Sabina were too big to fail in the turn of the new millennium, but they were definitely not too big in the end. So Oliver, it's back to you now with the default and termination rights, I believe.
Yeah, absolutely. Thanks, Phil. Yeah, let's talk about some of the legalities, as Ross called them. Unavoidable, I'm afraid, in a default and a termination scenario. So at this point, you've collated your full suite of transaction documentation. It's time to open them and refresh your memory as to what they say. Automatically, your eyes were drawn to the default provisions. What provisions you need to look at will be considered in light of the transaction structure. It will be necessary to read the lease and any loan documentation together. For example, in a conventional finance lease where you have an SPV lessor, a lease event of default will, in all likelihood, trigger a loan event of default automatically. In a more structured transaction, like a JOL or a JOLCO, that may not be the case. And to those unfamiliar with these structures, that can be slightly counterintuitive. And when you look through the events of default, it is possible that there will be multiple breaches or multiple events of default continuing at the same time. When we're looking at this, what we're really trying to find is a very clear breach. And generally that means either a payment default or an insolvency event of default. The clearer the breach, the less ambiguous the breach, the better. As we're looking at a payment default, it's binary. Either the money has been paid or it hasn't. It's easily documented. There's often lots of email traffic around it for evidence. It's worth noting that the recent wave of lease and loan deferrals has, in most cases, waived the pre-existing payment defaults. So all those leases and loans are now current, even if the lessees or the borrowers are paying a fraction of the originally scheduled rental. And particularly with respect to insolvency events, while it may be very clear when an insolvency event has occurred, there's often certain pre-insolvency actions which may not trigger the event of default. So you will need to look at the wording of the relevant provisions very closely and take advice from local counsel as well. And so talking about insolvency, I thought I would just reinforce the lawyer stereotype and throw some Latin into the mix here. This concept of an ipso facto clause. It's a very live issue, actually. An ipso facto provision is one which triggers the termination of a contract due to the bankruptcy or insolvency proceedings of the party, or the debtor usually in this case. And certain insolvency regimes restrict the operability of these provisions. Germany is a good example of this. We saw that on Air Berlin and more recently in Germania. And the UK is about to join the party as well. There is new draft legislation in the UK which is making significant changes to the UK's insolvency regime, which no doubt lots of people on this webinar will be familiar with to a certain extent. It's going through the House of Lords at the moment. We expect it to become law next week, and that will introduce for the first time into English law an ipso facto restriction in certain circumstances. Again, happy to talk about that later if we have time. A quick word on MACs, or material adverse change clauses. There's always been a nervousness about relying on a MAC to call an event of default. But in the aftermath of COVID-19, it's even more difficult, I think it's fair to say. The reason is that many governments have, at least in theory, offered to be a lender of last resort to airlines. And can you really say that there's been a material adverse change in the financial condition of an airline where the government has effectively offered to provide a backstop financial support? I think that sounds like a difficult argument to me. There's a few sort of cautionary items there and side issues to be live to. I will just focus on one because it comes up a lot. I get a lot of questions around this, which is that of what I've called unintended waivers. It's going to be very important to instill discipline in the deal team, particularly the sales and marketing team who are sort of airline facing. They need to be aware that the discussions they're having can potentially bind the company. So waiving obligations or agreeing to complete additional tasks can be agreed verbally. So I would just say that in any formal communication with an airline, which is or even may be in default, it's prudent to include what we call a reservation of rights provision to avoid any suggestion that your conduct operates as a waiver of the default. And then once you've established the event of default, if a decision's been made to terminate the lease, then let's look at the termination provisions. Generally speaking, a lease will require the lessor to take an active step to terminate, and some automatic termination provisions do exist, but generally there's a notice requirement. I'm going to talk about notices on the next slide, but specifically in a lease, no doubt those of you who've looked at a lease will see that you've got the list of events of default, which can run to several pages, and after that there's a long clause which deals with the rights and remedies of the lessor following an event of default. And this is very important, this clause, because a lessor will not, contractually speaking, be able to compel a lessee to take any action which is not prescribed in that clause. And a good example here is the grounding of an aircraft. It may be that the lessor wants the airline to ground the aircraft, but isn't quite ready to terminate. There's, that's a big decision that won't be rushed. But in the absence of an express grounding right remedy, the lessee is not obliged to ground the aircraft, and so that then becomes a matter of commercial negotiation. And just if I can, I know I'm running on, Phil, but just 1 minute on the enforcement process. In many jurisdictions, ownership rights are more readily recognized than the rights of a mortgagee. So while an aircraft mortgage is almost invariably a sort of prerequisite part of the security package in any secured financing transaction, the reality is that in practice, you will very rarely see the mortgage used as the means of enforcement. In fact, I don't think I've ever done that. More often than not, in a non-consensual repossession, you're focusing on enforcing through the lease, through your contractual step-in rights, which you've obtained through the lease security assignment. And so that notice and acknowledgement of assignment of the lease, which is, can only be a sort of 2, 3, 4 page document, it is really, really critical to get that right. And very occasionally we do see enforcement through a share charge, but generally, certainly amongst the sort of bank community, there's a limited appetite to take ownership of an aircraft onto its balance sheet. Sorry, Phil, I ran on a minute or two there, but is there anything to add, or shall I talk about notices?
At some point, we'll carry on, but we've had the question before this session, and we've just had one come in on the live questions. Surely this epidemic it's a force majeure, and I don't know if you want to answer it now. Feel free to go on to your next slide, but I think we've got to address that at some point.
Yeah, we do address that. We do need to address that. I mean, force majeure is under English law, is not a sort of doctrine which would interfere with the performance of contractual rights and obligations unless it's expressly legislated for in the contract. There are certain jurisdictions where force majeure relief has been made available to counterparties, but from a sort of English law perspective, looking at the performance of an English law contract, unless the contract provides for force majeure relief, then that's not a consideration. I suppose the additional point to make there is that if one is looking to enforce an English law contract in a jurisdiction where force majeure relief has been made available, for example, China and India recently, then you may find difficulties enforcing in the local jurisdiction. But from a sort of pure English law perspective, we don't sort of view force majeure, and the market view is that force majeure is not a way of a lessee wriggling out of its obligations under the contract.
Okay, I mean, if I was a lessee, an airline, I can imagine in the future when I'm negotiating either a loan from the bank or a lease of an aircraft, I will specifically be saying if there is something classed by the World Health Organization as a pandemic that leads me to ground an aircraft, I will expect not to pay. So again, we probably haven't got time to go into that, but will it be a new clause? Do you see this being a request that you're going to be getting in the future?
I think an airline can make the request, but I don't think they'll get much traction with it. It is a common and entirely consistent feature of all leasing arrangements in the aircraft world, at least, that lease payments and other obligations are performed on a hell or high water basis. And you might have heard that clause, the concept of hell or high water payments, which means that come hell or high water, the lessee will pay and is obliged to pay rent with very, very few derogations. I just don't see that changing even as a result of COVID.
Okay, so when we hold the next IBA Masterclass on advice to be given to airlines in negotiating future loan conditions, I'm sure you'll be willing to participate in that, though, Oliver. So
it'll be a short discussion, Phil.
Yeah, good. Okay, yeah, onto this slide then. That's great. Notices and lease termination formalities.
Yeah, it's not the most thrilling sort of slide title, is it? And it may seem overkill to devote a whole slide to this, to affect what is effectively serving notices, but it is really, really important. In fact, even the very best contingency planning can be undone by sort of simple failures on this front. So often as part of that contingency planning process, we are asked to prepare draft notices, or we will suggest that we do prepare draft notices in advance, which we then have on file should the airline's situation deteriorate. And depending on the situation, that can be a simple demand notice, which demands payment of an overdue amount, or a default notice, which formally declares the occurrence of an event of default, which in most cases will sort of set in motion a chain of events which may ultimately lead to repossession. The grounding notice we've discussed, a redelivery notice can be issued requiring the lessee to redeliver the aircraft at a specified location. And then, of course, the termination notice. That termination notice can either terminate the leasing of the aircraft under the lease or the lease itself. And that may sound like a fine distinction, but it's an important one. Again, happy to talk to that later. Each of those notices will include, as I mentioned earlier, the reservation of rights language. And as for the notice requirements, well, for that we need to look in the document. The thing with the notices clause is it's usually tucked away in what we call the boilerplate provisions at the end of the document. And as such, it's often overlooked. But that's a mistake, because the English courts take a very strict approach to the validity of service of notices under contractual notice provisions. And there's a leading case from 2014, which involved NatWest, where they sent a notice under an ISDA master by email to a client. Email was not a permitted method under that contract, and the judge held that failure to follow the contractive notice provisions rendered the notice ineffective. And so to avoid any issues further down the line, you really have to follow the notice provisions to the letter. If they say that you need to serve hard copy notices on green A3 size paper, then you must do that, else the notice can be declared ineffective. And when time is short, you can't be in that position. And in terms of who issues those notices, well, you need to look at your transaction structure to see who needs to send notices to whom. And there may be multiple notices are needed, particularly in a structured financing, for example, where you have a lending arrangement, potentially multiple tranches of debt, and also a structured leasing arrangement. I would always advise sending notices to a guarantor, even if the notice provision does not absolutely require that. I mean, if you know that the addressee or contact details have changed, but no formal notification has been made under the terms of the lease, then consider sending notices to both the old address and the new address, which you know to be the correct one. In terms of how you actually serve the notices, well, it's difficult to believe, I think, that in 2020, most notice provisions still provide for service of notice by fax, and some counterparties absolutely insist on that. But experience tells us that unplugging the fax machine is one of the very first things an airline in distress will do. And often the lessor is left with post or courier or by hand delivery as the only option, and obviously that has time considerations. That's created a huge amount of problems during the COVID-19 lockdown. You're simply unable to get notices out in some cases, or at least huge delays in doing so. And please don't assume that just because you've been communicating day to day with the airline by email, that will override the contractual agreement. When it comes to notices, really have to follow the notice provisions. The only other point I'd make is about business days. I saw a lease the other day that I wasn't involved in the drafting of it, but it had 8 different cities in the business day convention. So what was a 3 business day notice period turned into an 11-day period, which clearly wasn't the intention at the time. And just a quick word about letters of credit. I just wanted to sort of make the point that demands under LCs must be done in accordance with what we call the doctrine of strict compliance. So you should absolutely check the presentation and demand conditions in the LC are met to the letter. Otherwise, the issuing bank can reject the demand. And generally, we're seeing a lot of LCs called very, very close to the expiry date. And so there's no room for error. And I've had some unfortunate situations where errors in submitting the demand have led to the LC lapsing. Just a case in point, I had to submit an LC demand recently. I had to put the wrong MSN into the demand certificate because there was a typo in the form of the letter of credit. So despite it being an obvious typo, you really have to follow to the letter. Now, no doubt people have got war stories involving letters of credit, but I've seen many LC demands rejected. There was one recently where there was a typo in the name of the beneficiary on the original letter of credit. That was sufficient to allow the issuing bank to reject the demand. And LC banks often use delaying tactics, for example, refusing to pay until they have evidence of the relevant lease event of default. You know, that's very rarely a requirement, a strict compliance requirement of the LC. And sometimes banks will refuse to pay before they've been put in funds by the confirming bank, and that simply isn't the way that they're meant to work. There's 2 acronyms there, UCP and ISP. Different rules govern the LCs, but I won't go into those here. I think that's probably enough on that slide, Phil.
Well, you thought it was enough, but we've had a question come in about if the fax was the only method to serve notice, what do you actually do then? How do you get past that one?
I've never seen a lease where fax is the only method of service. There will inevitably be a fallback to a courier or mail or by hand delivery option. But if fax is the only electronic method of service, then and the fax machine has been unplugged, then you should keep evidence of the failed fax transmissions to show that you tried to deliver in case that is required in evidence. But ultimately, the notice will need to be served physically through a courier or mail.
Yeah, I mean, you started off this slide by saying, you know, it does seem, you know, like this is fairly obvious, but it's so crucial because I think we've been in situations on the ground at the receiving end of what needs to happen, and we've just had to wait. We haven't been able to do anything for sometimes 2 or 3 days. But on that note, next slide, please, because we're going to run through some of the processes that we follow. Now, I mean, Ross, I think we've gone through the first main headings of establishing location and the importance of the legal team liaison. I think you could sort of run through the storage options because, you know, clearly, you know, we put it in country versus out of country, but there are presumably quite a few options or options that need to be considered to make sure you're getting your aircraft into the right place.
Yeah, sure. As part of the contingency planning, it's no good being in a position of having repossessed the airplane and sitting at the end of the runway thinking where are we going to go. So as part of the contingency planning, we would look to where is the most suitable place to take the airplane. If we were in South America or North America, I would suggest North America, but that's not necessarily true. We'd look for a storage facility which has the capabilities for that type of airplane. We wouldn't like to keep an airplane for a long period of time parked in a coastal region, for example. You know, that's something that we'd look to move the airplane straight away. Securing storage options that part, airport access and security. So how do we get into the airports to repossess the aeroplane? That's part of the contingency planning. Historically, we found early engagement with the airport authority for where the aeroplane is currently parked has been really advantageous to us because we've had the backing and the support from the airport. And arranging camo support. So the Continued Airworthiness Management Organisation will be the organisation responsible for maintaining, issuing the work packs to maintain the aeroplane in a storage program. Arranging that ahead of repossession is key, giving them access to the records as and when you receive the records. That's how you maintain the airworthiness of the aeroplane or the storage program for which it's in. Arranging alternative storage facility, arranging ferry crew, fuel, flight planning. So we've got a number of operators that we go to that specialise in ferry flights. They'll organise everything from their end, including the fuel and the flight planning. And we have some indicative costs, which you'll see later, but obviously that can vary. So if we were repossessing an aeroplane in Australia and for some reason we wanted to move it to Europe, those costs would be double for moving around in a region. Ferry flight to the facility with the MRO. So we might take the aeroplane, put it in storage for 2-3 months, however long, until we find a new operator for the aircraft. Some of the storage MROs have the capability to paint the aircraft, refit interiors. Some storage facilities are purely storage. So you may have to fly the airplane from that airport to a facility which has an MRO, which can paint the airplane, put the new coloured seat covers in, all those types of things for a future operator. So you might be involved in 2 ferry flights, not just the one, depending where you are in the world and where you look to store the airplane.
Yeah, and I think this again, this really does become something which we'll be liaising with the legal team. In some cases, aircraft have been deregistered and we have to find an alternate register fairly swiftly. We've done that, I think, in India, and we've used the Isle of Man register, for example. But that then means you've got the new aviation authority will want evidence that the aircraft has been properly maintained. So yeah, that takes quite a considerable amount of project time. We'll probably come back to some of those via the questions, but we will move on. Oliver, we're going to be talking about some of that. Getting hold of the aircraft can be quite tricky. Can you tell us about the other creditors that we might be dealing with?
Yeah, happy to. Of course. So when an airline collapses, there's obviously going to be a number of different, what we might call operational creditors, who are going to be owed money by the airline. What's important to realize is that there's only a small subset of these creditors who actually have the right to assert a lien or to otherwise detain the aircraft. Most obviously, people think of repair as liens. I think people understand that an MRO or a repair shop can retain the goods on which it's performed services until it's been paid. In the UK, the main airports have a statutory right to detain aircraft pending amounts owing to them having been paid, and actually that extends across affiliated airports within the same ownership. And the CAA will direct the airports to detain aircraft pending payment of those air navigation charges, whether Eurocontrol or domestic. But to assert that statutory detention right, sometimes called a lien, although technically it's not, the UK Airport Authority must perform what's called an overt act. That's what the legislation and the guidance says. There is unfortunately no guidance on what that might be, but we've all seen photos of snowplows parked behind the Monarch and the Thomas Cook aircraft when those airlines fell over. That would seemingly qualify as an overt act, albeit an unconventional one. And more conventionally, the airports will simply place a notice on the aircraft. And actually, when Thomas Cook went into liquidation, The more experienced airports were literally waiting for the aircraft to land and to apply notices the moment that they did. Other creditors, ground handlers and fuel suppliers, catering providers, have no legal right, in the UK at least, to detain the aircraft. So if there's some ground handlers' equipment parked behind the aircraft stopping it leaving because they're demanding payment, that really constitutes unlawful interference with another person's property. And part of our role is to manage those. It's a bit like whack-a-mole sometimes, and sending sort of cease and desist letters to the companies to get them to move their kit if the airport doesn't do so. Some creditors get creative, and actually in one airline bankruptcy in Europe recently, the fuel supplier obtained a freezing order from a local court, which covered all fuel provided to the airline but not used, which included fuel in the tanks of my client's aircraft. So if the lessor had flown the aircraft out, then it would have been in breach of the court order by burning fuel. And we thought about draining the tanks, but that would also have been in breach of the freezing order, because it would have been interfering with the fuel. But we found a creative solution in the end, I have to say. Trade secrets there, but you know, it does illustrate the lengths that some creditors will go to, and you know, putting aside the lien position that I just described, it's not inconceivable that a court will order or make sort of additional supplementary orders that one needs to look at. And it may be the case that you have to go to court to get those removed. The thing is, of course, that takes time, and the ground handlers and the caterers know it takes time, and time is not a luxury which a lessor or a financier has while an aircraft is stuck on the ground at an airport, and often a settlement is reached just in the interest of expediency. And there's quite a lot of sort of interplay between insolvency regimes on the one hand and the ability to assert liens and detain aircraft on the other. There's quite a lot of detail there. I'm happy to take questions on that later, but otherwise I just thought the final note here is around the sort of mitigation of that risk. It is possible, of course, to search Eurocontrol to find out outstanding charges against an aircraft or against an airline's fleet. Some leases provide sort of generic airports authority letters, which allow a lessor to seek inquiry of an airport for outstanding charges. But of course, the issue there is tipping off. And if an airport sees you making inquiries, then you know it might well assert the lien anyway. So whether the game is up at that point, it will depend on the facts and circumstances. And there's a sort of technical point on engines. I mean, there's a very legalistic argument that repossessing an aircraft with someone else's engines on it brings with it a risk of lawful, it should be unlawful interference. But Ross, I mean, practically speaking, you've come across some situations where engines can be swapped out sort of consensually?
Yeah, so the last 18 months we've done some repossessions involving 777s. There was 2 lenders involved on that fleet of aircraft. Early engagement with both lenders got us an agreement in place where we could move airplanes around and ship engines back to wherever they needed to be after the ferry flights. Problem that does present, especially in a big default in a big airline with similar types of engines, is where do you find the shipping cradles to move all of these engines or store them? The engine cradles themselves are very expensive. They're a $300,000 commodity, and there isn't many of them available because no one intends to swap massive amounts of engines at any one particular time. So an airline and MRO will probably have 2 or 3 of each type of cradle available, but once they're taken up or there's engines currently stored on them, how do we get these engines off? We've used aircraft in the past where we've hung engines on airframes for storing them rather because we didn't have cradles available.
Okay. Actually, well, while we've got you then, Ross, let's have the next slide up. And we're talking here about the costs of this action, and Pete, feel free to dive in as well, because maybe when you were on the the financing side of things, there was a lot of eyebrow raising in terms of the costs of this type of effort. So actually, I will ask you a question first. So how does the bank deal with this? Do they have a sort of an emergency fund when they start a loan situation, or do they have to run around trying to find funds in situations like this?
From my own experience, when I was in banking and either providing debt directly to airlines or debt to lessors, the simple answer was we didn't have a plan, and it was necessary to receive advice from technical advisors and or lawyers as and when matters came up that we needed to approve funding, and then that would be, you know, if funds were provided, then it would be taken down as an increase in the overall obligations and debts exposed in respect to that aircraft or loan facility. And the important thing is that even if you don't have that kind of budget set up, have the decision-making process and people aware of what's required. Some people do have, you know, a fund set aside, but that's, I would say, within banks, that would be the exception rather than the rule. I think it's quite unusual for that. It tends to be as and when issues do arise. And then just, I was trying to come in on a point with the last slide, but unfortunately technology defeated me with a mute button. It's a very common expression these days, you're on mute. But in terms of unpaid costs that create further issues down the line, we did experience significant difficulties in India with Jet, because the software license provider that managed all of the records for all of Jet's aircraft hadn't been paid. And therefore, all of a sudden, people that were trying to do a lot of work with regards to rebuilding redelivery Bibles and documentation suites for the entire history of an aircraft, all of a sudden, it was switched off. Now, those records do belong to the owner of the aircraft. So it wasn't that you couldn't get them, but you couldn't access them through a regulated and approved software system that meant you could deal on a remote basis. All of those records that you got via the software system came out with a big watermark across them saying that they were now in an uncontrolled environment, and therefore you couldn't rely on them. So in that circumstance, what would have been ideal was perhaps the receiver or a group of lenders actually say, well, fine, we will pay the software provider to make sure that continues going. In reality, what we had to do was to have a team of people on the ground, literally going through every single piece of paper in respect of a whole portfolio of aircraft in order to be able to export those aircraft and get them out of India. So not necessarily a lien, but a practical consideration that needs to be borne in mind, that, you know, a relatively small payment to the software provider to keep the system up and running would have saved an awful lot of money going forward. And I suppose that now relates to unwanted repossession costs that could be avoided.
Yeah, indeed. I mean, Ross, can you just take us through some of these? We've got some very ballpark figures here, and we do use that word illustrative on every one of these. Yeah, we've been asked a question, for example, about, you know, typical costs of camo monitoring. We do cover that in the ongoing payments, but immediately, of course, you're going to have to get hold of the asset and secure it. So do you reckon that budget is about right? That, you know, it's probably $100,000 just to secure the asset and get it somewhere where it's safe.
Yeah, sure. It's obviously indicative of where we are in the world geographically and where we're looking to take the aircraft. But as a rule of thumb, the insurance, parking, the ferry flights, it runs into probably the six figures. The ongoing payments for the storage facility where we've taken the aircraft to, and the camo monitoring. The camo monitoring, that 30,000 is for the 6-month period as per the above. We pre-COVID-19, we would like to hope that we'd be able to replace the airplane into another operator within 6 months. However, the demand for aircraft has decreased significantly over the last few months. So those storage programs may run into several more months than the 6-month scenario we're giving there. The future payments are in regards to, we find a new operator after we repossess the airplane, what do we need to do to place that aircraft into the operator? There's some legal compliance issues we might have to perform in terms of modifications, ADSB, things like that, where they're mandatory in certain regions. As a rule of thumb, we wouldn't expect the future operator to pay for those types of modifications. They could be subject to a commercial agreement, of course, but making the aircraft as appealing as possible may have some charges for the owner of the aircraft. The repaint, the reconfigurations, they can be subject to commercial. We have a $500,000 figure there for future payments, which could be double, could be half, depending on when and where you're looking to place the aircraft. Then we have the warning of, if we repossess an airplane prior to it being due a major overhaul, a major check, that who's going to incur those costs? It's unlikely that any next operator would be willing to split costs of those types of overhauls. Engine refurbishments at $6 million, and landing gear and APU overhauls, if they're due when you repossess the airplane, probably going to be your costs.
Yeah, I think I mean, one of the associated with this, you know, we've been asked by a lot of some of the ABS funds, really, or the investors in those, where is there enough maintenance reserves to get work done? I think there's going to be a bit of a crunch point with some of those. Obviously, if maintenance reserves haven't been taken, then you're left with no pot at all. So I think there's still going to be things in the coming months which will cause issues there. Actually, Oliver, we did have a question about LCs for maintenance reserves, and the fact that because these often cover a period of 12 months in advance, is there a risk that in the event of bankruptcy that the administrator or court could ask for the cancellation of that LC or mandate it at a lower value, as it could over collateralize the obligation if the default was in the first few months of that period? Have you got any advice on that point?
It's a very good question. The overriding point about any insolvency proceeding, particularly in perhaps less sophisticated jurisdictions, is that you can't really predict what's going to happen. And so theoretically, yes, it's possible that a court can require or ask for cancellation of an LC. The reason I think that's very unlikely is that the LC is not an obligation on the airline. The LC is an obligation on the issuing bank in favor of the beneficiary of the LC. There may be, and is in fact likely to be, a sort of back-to-back reimbursement arrangement whereby the airline is obliged to reimburse the issuing bank for any payments made under the LC. But that is ostensibly an obligation of the issuing bank. And actually, in an insolvency scenario, the existence of letters of credit is actually quite helpful when one considers the clawback issues which arise. It is very different making a demand under a letter of credit of a third-party bank than it is, effectively applying security deposit, which is money that has been paid by the airline to the lessor, even if the lease says that the security deposit represents the sole and unencumbered property of the lessor, which it usually does. And the lease itself, what happens when a demand is made under the letter of credit will be prescribed by the lease itself. But normally the LCs can be called, and the cash can then be just retained by the lessor or applied against overdue payments.
Okay,
that's a very good question.
Yeah, I mean, we have got to 10 o'clock, but I do want to grab an extra 5 or 10 minutes, really, because we've still got over 300 people listening to this, so they've obviously got nothing better to do. So I would just want to ask you, we've had a question saying, can you speak a little bit more about automatic termination provisions? Could they be used to avoid the fleet-wide lien in the UK For example, the leases are automatically terminated upon the occurrence of the first detention of an aircraft by an airport pursuant to S88. I hope I haven't surprised you there, Oliver, and that you can respond to that one.
Yeah. So yeah, look, again, it's another very good question. S88 refers to Section 88 of the Civil Aviation Authorities Act 1982, which is the statutory basis for an airline to detain, for an airport to detain an aircraft pending payment of charges. There's a related point there, and I'm glad somebody's asked the question. It's what we call the fleet lien. People might have heard of that. And what that does, it allows an airport to recover charges from incurred by the airline's fleet from one or more specific aircraft. So a good that all sounds a bit theoretical. A good practical way of illustrating that is somewhere like Monarch, where whether it was Manchester or Birmingham. Say there was 10 aircraft in Manchester Airport, but 30 aircraft had been using the airport during the sort of run-up to Monarch's administration. The airport was able to detain those 10 aircraft and recover from those 10 aircraft the charges across all 30 aircraft that had been using the airport. And that's called the fleet lien. The UK is a relative outlier there. Theoretically, the fleet lien can exist in other jurisdictions, but actually the UK is the only sort of major authority, as far as I'm aware, that actually enforces the fleet lien and it exists in statute. The other point to make is that, and this is where it gets quite interesting, I would say fun, but I think the clients might disagree with that. There's a timing consideration there, because it is possible to break the fleet lien, and you break the fleet lien by terminating the lease. And the reason that you can break the fleet lien is that the legislation makes it clear that that one is looking at the operator of the aircraft when the fleet lien is asserted. So if you are if you're still the airline at the time that the lien is asserted, then the fleet lien bites. If you've terminated as a lessor, if you've terminated the lease, then the fleet lien is broken, and the airport would only be able to detain your aircraft and recover charges which are aircraft specific. I hope that's clear. And so often when we know there's an airline in insolvency or sort of pre-insolvency position, we've prepared, it goes back to what I was saying earlier, we've got the termination notices ready to go, and it's a question of who gets there first. Can we serve the lease termination notice before the airport undertakes, remember that what I call that overt act, to assert its statutory detention right. And actually there was an airline bankruptcy, can't say which airport, can't say which airline, but we managed to get the termination notices in less than a minute before the fleet lien was asserted. And that meant that for that particular aircraft and that airline, the fleet lien didn't bite, and that saved the client over 6 figures. So, that's the sort of real life example of where expediency and timing really counts. The timing of the various emails showed it was less than a minute between us terminating the lease and the assertion of the lien.
Yeah, so when we were talking about how important it is to get that contingency plan in place, then obviously the sooner the better. Look, we have overrun by 5 minutes, but I think it was well worth it because we had some great questions coming in. The next slide is the selected takeaways for all of you. And here, forgive me, Oliver, I will refer to some of these legal considerations. Establishing the signing processes and approval procedures, beware of unintended waivers, and always reserve rights. The special attention required to the notice provisions, particularly the method of service you mentioned. Not all operational creditors can impose liens or otherwise detain aircraft. And on the practical and commercial end, just make sure that you've got the up-to-date information on where your aircraft is now. It may well be parked away from the main base. Be prepared, engage now with all of the service providers and have agreements in place ready to go, and explore the options of an early or voluntary surrender of the aircraft and what they may present. Now, the next slide actually says questions to the panel, but as you can see, I've very carefully interwoven those into the previous discussions. So really, it's just for me to bid you all farewell and to say that we're using data from our online data intelligence platform, IBA IQ. We're offering demonstrations. Do drop us a line or register through the website if you'd like to look at the system. Please do get in touch with any of us if you've got anything that we've discussed today that is especially relevant to your situation. Thank you all for attending today's session. You will receive a follow-up email with a link to view the recording of today's session and the associated slide deck. So on behalf of IBA, Clifford Chance, Oliver, Peter, Ross and myself, thanks for joining us today. Special thanks to our marketing team of Lucy and Dom, led by Mel, for organising us over the past week or so. So it's goodbye from me. See you all again soon. Bye now.
Thank you very much.